As a child, I remember watching Marlon Brando testify for his son, and I thought there would be no moment more entertaining in a trial than Marlon Brando being asked, will he tell the truth?
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth. So help you God?
No.
I honestly thought the judge was going to get whiplash. The way he twisted his neck so fast after Marlon Brando said no.
No. No. I will not swear on God because I don't believe in the conventional sense.
Then, of course, we had what was called the trial of the century. I watched the entire Bronco chase, and there was unbelievable amount of DNA evidence, but still, they got OJ off. I mean, the lawyer started rapping, and that was it.
If it doesn't fit, you must acquit. You must acquit. If it doesn't fit, you must acquit.
And O.J. Simpson over there?
And he has a rather large head, large head, large head, large head. You must acquit. If it doesn't fit, you must acquit.
Still thought Marlon Brando's was a little bit more entertaining. Then, of course, we had Johnny Depp and Amber Heard.
This is a picture of you on a black leather couch, passed out, correct?
Passed out's an interesting way of putting it. Maybe asleep.
Where is it? What residence?
That's in Boston.
Oh my God. I mean, Johnny Depp was saying things that no human ever says about anything.
That's ice cream on your lap, correct?
It is indeed. And if you'll notice, my right hand is in my pocket. So I wasn't participating in the Festival of Ice Cream.
I was convinced there was no trial going to ever be as entertaining as Johnny Depp and Amber Heard. But then again, one trial happened. Beat the two-time Oscar winner, Marlon Brando. Beat movie icon Johnny Depp. And beat NFL superstar, Heisman Trophy winner, O.J. Simpson. One guy. That's right, Darrell Brooks. The best thing that happened in that trial was that he decided to defend himself.
Do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are. If you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
In the courtroom here today, Officer Schneider?
Objection, hearsay.
Overruled, she may answer.
I'd ask Mr. Brooks be directed to remove his mask so that Officer Schneider can identify him, please.
Objection, I never heard an answer to the question.
It has not been answered. Mr. Brooks, please remove your mask. Thank you.
Officer Schneider, is the driver of the red SUV that you've just described for this jury present in this courtroom today?
Objection,
Yes.
hearsay.
Can you please point him out by where he's seated and what he's wearing?
He is seated over here at the table wearing a gray suit.
That's the man you saw driving the red SUV as it sped past you?
Yes, it is.
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
That at 8:42 a.m., this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. You can see that he is seated with his back
to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. Again, you're doing this tactic.
Because it's not a tactic, it's facts.
What we're talking
It's
about
facts.
to some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. You go over there when you frankly demand removal under Illinois versus Allen.
I didn't demand anything.
No, your conduct did. So you
My
can
conduct
sit.
didn't demand anything either.
All right, Mr. Brooks, please sit
changing-
down.
You keep changing
And I'm
the
going to continue
jurisdiction.
with my sentencing remarks.
You keep changing the jurisdiction. Jurisdiction is a subject matter jurisdiction that has yet to be proven on the record. In
Mr.
that
Brooks?
court and in this one.
Please sit down.
I would like to go back to the other court.
It's not a courtesy to you. If you'd like to specifically waive your right to be physically present, then I will entertain that. Otherwise, you need to sit down.
I never waived the right to not be present.
That's because you forfeited your right to be present by conduct. You're now back in this courtroom.
Your Honor, I wrote 3. I did what you asked me to do.
You never once pledged to me, sir, that you would not interrupt. And you're demonstrating by being here that you continue to interrupt.
Man, I ain't trying to hear all that, because at the end of the day, I did what you asked me to do. You told the bailiff to tell me.
Mr. Brooks, this is not a debate.
You told the bailiff to tell me that I had to
It's not a debate. You
write.
asked to come over here, and I honored that,
Well,
and
I
I brought you
exercised my
back.
right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never
Judge
had to do
Darrell.
that before. You've never required that before.
That is actually not true, sir.
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short, sometimes an extended period of time.
You are just simply trying to delay the inevitable. Please sit down.
I don't care about the inevitable. It was
I need
already
to
written
get
from day
through
one
this
what was going to
hearing.
happen. It doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have not been.
Please sit down.
And then Your Honor, and then you
Mr.
always make it seem
this is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm waving this for like 20 minutes, saying I would want to come back. I'm doing this.
You're here now.
Can I come back? Can I come back? Can I come
sit
back?
down.
It wasn't honored. And then I said,
can
okay,
finish.
I'll write this, and I'll see if Your Honor can see it on the screen. The objection sign saying,
Mr.
I
Brooks,
exercise my right
if
to
you
be present.
stop for a
May I
minute,
have the order of the court?
I'll explain it, but you have to stop I can explain it.
Your Honor, I did what you asked me to do.
Actually not.
Yes.
Let me explain
And if you would like. If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't
and
answer
that
the question, though.
matters.
That doesn't answer the question.
Please sit down and I will explain and
Your
remain
Honor,
quiet
with all
without
due-
interrupting me.
With all due respect.
That doesn't mean you're respecting me, so please sit down.
With all due respect, you told the bailiff when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated,
I don't need a history
you always
lesson of
stated
what I've done.
that when I exercise my right to be present,
Untrue.
you've
Untrue.
always said,
Untrue.
we have the record. We have the record. We can dig into the record.
Mr. Brooks?
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
Which you're
I've
demonstrating
never
right now that you have absolutely
Your
no
Honor,
ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I told the bailiff I would like to be present. You told the bailiff if he wants to be present, he has to put it in writing.
And pledge to me that he will not interrupt me.
I put it in writing.
Without a pledge.
So why am I here?
Because I'm going to move on to another phase of this hearing, and I thought it important that you be here in person.
So I was here.
But you didn't reclaim your right to be back here.
Then why am I here
am
then, Your Honor?
allowing it to
Okay,
happen.
and I respect that you're allowing it, but still, it doesn't answer the question, though, Your Honor. It does not answer the question.
Mr. Brooks.
Your Honor, as a
Mr.
public
Brooks.
servant, I have the right to ask questions
Sir,
of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down, then you are in direct disobedience of a court order. Sit down and be quiet so I can make the appropriate record.
Can you tell me what the
All
court
right,
order
he's
is?
not going to obey. He's now forfeited
I
his
didn't
right
say I
to be
wasn't gonna
present.
obey.
He will go into the
I
other
didn't say
courtroom.
I wasn't going to obey.
We'll be
I
in
just
recess
asked what is the
until he's
order.
there.
I just asked what is the order.
I would like to issue the court an apology from me in regards to my actions last week during the trial.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody.
If we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because that's a lie.
Let him
Because at the end of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight.
Is there only one witness left?
Yes. For that. Yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Who's supposed to come at 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me try to, I have it.
I accept for value in return for value this paperwork.
Thank you. If everyone would have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There is a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 906.11, I have the authority and the discretion on that, so please call the witness who's available.
So I'm being rushed to jail.
No, sir, I'm trying to have an effective and efficient use of all of our time. It's under 906.11, I do have the authority and just my inherent authority over this case to require you to call the next available witness. In my opinion, we're not entirely cooperative yesterday with the process, and so I told you,
You also didn't provide me with that list.
you were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no, you
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her.
Yeah,
She's
the
on
re-
your list. She was on the listing, as I understand it, with the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of
why
witnesses.
is it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I told you what I believe my authority is. Okay,
You
if
told
you
me
don't want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
You told
fine.
me your
Your
authority.
objection
I'm
is
not
noted
debating
on the record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise an
said-
issue with about
What
Detective
I said
Guzman's
was
testimony.
I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. It is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the state
saying
did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did. in
Did
that
they have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be
do it.
provided with. We're going to call this witness at this time
But they're
and this witness
able
at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses to frankly help you. Get
No,
the
it's not
witnesses
helping me by
to
it's helping
court.
the state
And no.
by being able to say if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's
I
not true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's
Yesterday,
not my fault.
I very
It's not my fault they
expressly-
weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm gonna stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
wanted to be
her,
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law-
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have
witnesses,
to cooperate with this process,
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this as a
asked-
game. That's what
me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going
unfair
on.
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And I
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
Nah,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
To address subject matter jurisdiction for the record has yet to be proven.
Objections are noted. I will not be addressing subject matter jurisdiction.
For your information, he keeps trying to, the verdict just came in and he keeps trying to derail the entire trial by saying subject matter jurisdiction. Subject matter jurisdiction means basically, does that court have the jurisdiction to even have the trial? Of course they do. It's a ridiculous point that he keeps making about subject matter jurisdiction.
Bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor. Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor? We request a written judicial finding of fact and conclusion of law on this issue, Your Honor.
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor.
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant?
Thank you, everyone.
Object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff? We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide. Count 2 of the information. Guilty of first-degree intentional homicide as charged in count 3 of the information. Guilty, 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 guilty in count 11. Guilty in count 13. Guilty, 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 charged in count 19. Guilty, 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 charged in count 25. Guilty, guilty, guilty in count 32. Guilty, guilty, guilty in count 37, in count 41, in count 36, count 42, count 43, guilty, count 73, guilty in count 75, count 76, guilty. Mr. Brooks, would you like me to poll the jury?
Yes.
The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3.
It is. Yes.
Verdicts.
They are, Your Honor.
Verdicts. Yes. Thank you.